Okay, I am back from the body break, and then without any further ado, I will ask the legislature's indulgence in the regulations to be employed or followed. Since Section 12(1)(d) of the Constitution of the Republic of South Africa 1996 provides that everyone has the right to freedom and security of the person, which includes the right not to be tortured in any way. And mindful that the Republic of South Africa has a shameful history of gross human rights abuse, including the torture of many of its citizens and inhabitants. And mindful that the Republic of South Africa has since 1994 became an integral and accepted member of the community of nations. And mindful that the Republic of South Africa is committed to the preventing and combating of torture of persons, among others, by bringing persons who carry out acts of torture to justice as required by international law. And mindful that the Republic of South Africa is committed to carrying out its obligations in terms of the United Nations Conventions against torture and other cruel, inhumane, or degrading treatment or punishment. And since each state party to the United Nations Convention against torture and other cruel, inhumane, or degrading treatment or punishment must take effective legislative, administrative, judicial, or other measures to prevent acts of torture in any territory under its jurisdiction, the Minister of Defense and Military Veterans has, under Section 62L of the Defense Act number 42 of 2002, made regulation in the schedule with a preamble that whereas the Defense Force is a national asset which is mandated under the Constitution to be structured and managed as a disciplined military force, and in accordance with the principles of international law governing the use of force, and whereas the Defense Force is essential in the defense of the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy, and whereas the Defense Force provides a soldiering career wherein members entrust their inalienable right to life guaranteed in the Bill of Rights of the Constitution to the nation and the state. And whereas it is an unavoidable reality that when a soldier is recruited, her or his family becomes a part of the larger family, Defense Force family, to share in the joys, anxieties, and sometimes unfortunate outcomes of service, including maiming and death. And whereas it is essential for an effective mechanism to be created to provide for a necessary duty of care to the soldier and his or her family, and whereas it is therefore necessary to create a working environment for the soldiering professionals that is positively conducive to discipline, and whereas these factors define the uniqueness of the soldiering profession. In line with the uniqueness of the soldiering profession, kindly consider the attached hereto SVM1. President Lieutenant Commander Sylvester Madala Mangolele is a statutory body in terms of the Constitution or the law pending the dissolution of the 6th Parliament before expiry of its term as obligated in terms of Section 50 of the Constitution. SVM1 is the sworn statement made on 24 February 2021 at the place of New Beginning in Bolsmore. Crimes or offences committed. The defendants are guilty of high treason as persons owing allegiance to the Republic of South Africa and have unlawfully engaged in conduct within or outside the Republic with the intention of overthrowing the government of the Republic, coercing the government by violence into any action or inaction, violating, impairing, threatening or endangering the existence, independence or security of the Republic, changing the constitutional structure of the Republic. The treachery is achieved by contravening the provisions of Section 4 of the Prevention of Combating and Torture of Persons Act 13 of 2013, and the defendants are guilty of an offense of torture as persons who commit torture, attempt to commit torture, or incites, instigates, commands or procures any person to commit torture against the plaintiff, his children Nyuko Mangolele and Aluta Songelwa, his entire family, country, and its people. Furthermore, persons under the employ of the defendants participate in torture or conspire with public officials to aid or procure the commission of or to commit torture, and intentionally inflicting severe pain or suffering to the plaintiff, whether physical or mental, for such purposes as to punish him for an act committed by the defendants, or intimidate or coerce the plaintiff to do or to refrain from doing anything, and subjecting the plaintiff into slavery, treatment or punishment that is cruel, inhumane, or degrading. Chairperson, what is humbly requested to happen is that the Legislature must fulfill the obligations imposed in terms of the objects of the Public Finance Management Act 1 of 1999 and secure transparency, accountability, and sound management of the revenue, expenditure, assets, and liabilities of the plaintiff. The Legislature must give effect to the Republic's obligation in terms of the United Nations Conventions Against Torture and other cruel, inhumane, or degrading treatment or punishment committed by the defendants, and provide for the offense of torture of the plaintiff and other offenses associated with the torture of the plaintiff, and prevent and combat the torture of the plaintiff within or across the borders of the Republic, and provide for matters connected therewith. And the Legislature must, in terms of Section 2 of the Prevention of Combating and Torture of Persons Act, give effect to the Republic's obligation concerning torture of the Convention, in particular the recognition that the equal and inalienable rights of all persons are the foundation of freedom, dignity, justice, and peace in the world. The promotion of universal respect for human rights and the protection of human dignity. That no one shall be subjected to acts of torture. Provide for the prosecution of persons who commit offense referred to in the Act, and for appropriate penalties. Provide for measures aimed at the prevention and combating of torture, and provide for the training of persons who may be involved in the custody, interrogation, or treatment of persons subjected to any form of arrest, detention, or imprisonment, on the prohibition and combating of torture. When interpreting this Act, the court or independent and impartial tribunal or forum such as the Legislature must promote the values of Chapter 2 of the Constitution and the achievement of the above objects. Chairperson, the required proof is that all parties are directed to bring all documentation on their respective record in relation to the plaintiff, having regard of the obligations imposed in terms of Section 32 of the Constitution, that the plaintiff or everyone has the right to access to any information held by the state and any information that is held by another person, and that is required for the exercise or protection of any rights. National legislation must be enacted to give effect to this right and may provide for reasonable measures to alleviate the administrative and financial burden on the state. And what you have in this particular regard is now excuse me, SVMM1, which is a sworn statement by Lieutenant Commander Sylvester Volane Madala Mangolele, 24 February 2021. In defense and protection of the Constitution or the law against all enemies, foreign and domestic, I, 99004046 MC, Lieutenant Commander Sylvester Volane Madala Mangolele, take over as President of the Republic of South Africa pending the dissolution of the 6th Parliament before expiry of its term as obligated by the provisions of Section 50 of the Constitution. In terms of Section 4 of the Constitution, I declare by proclamation the replacement of the terms "Let us live and strive for freedom in South Africa, our land," with the terms "Let us live and enjoy freedom in the universe, our home." The Universal Declaration of Human Rights and the supremacy of the Constitution and the rule of law prohibits any form or kind of slavery, and it is only a slave who lives to struggle, attempt or strive for freedom in their land. The Bill of Rights is a cornerstone of democracy in the Republic of South Africa, and Lieutenant Commander Sylvester Volane Mangolele is simply fulfilling the obligations imposed in terms of the provisions of Section 13 of the Constitution, and in any event, Lieutenant Commander Sylvester Volane Mangolele does not obey a manifestly illegal order as obligated in terms of Section 1996 of the Constitution, read with Section 2E of the Defence Act and the Code of Conduct for Uniform Members of the South African National Defence Force, signed by the President Sylvester Volane Madala Mangolele, the President of the Republic of South Africa, Lieutenant Commander. This is as a result of prayer 1 or second prayer after the matter is enrolled in terms of its agency, as alluded to in the document, where you are saying, declaring the axiom, "Let us live and strive for freedom in South Africa, our land," be replaced with "Let us live and enjoy freedom in the universe, our home," in terms of Section 4 of the Constitution. And when you go to that one, there is SVM 1. And to bring you again to the prayers before the National Assembly, is that the National Assembly must declare that the plaintiff be not deprived of freedom arbitrarily or without just cause since 20 June 2018 as guaranteed in terms of Section 25 of the Constitution. And we look at 2. SVM 2, it takes us to this particular reality in terms of SVM2. This is SVM2, and this is the reality that the legislature must look at in terms of Section 25. And I will take this opportunity to take you to Section 25 and the obligations imposed in terms of Section 25 by bringing this thing to here just closer, because we are talking about the Constitution. Yes, and then the Constitution, the preamble. Let's go to Section 25 of it. Section 25 reads, no one may be deprived of property except in terms of law of general application. General application? Does everyone live on the street? No. And no law may permit arbitrary deprivation of property. Does the plaintiff have this particular property? The answer is no. The plaintiff is without his car keys. His car keys are in terms of Section 2012A of the Constitution, with the incumbent President Cyril Ramaphosa. This property has been auctioned, as is submitted via a letter to the attention of the plaintiff. Property may be expropriated only in terms of law general application, for a public purpose or in the public interest. Is it in the public interest or public purpose that a person must live on the streets? No. Subject to compensation, the amount of which and the time and the manner of payment of which have either been agreed to those affected or decided or approved by a court. Am I being paid to live here? In fact, I'm being caused to pay heavy bills in that particular regard. The amount of compensation and the time and manner of payment must be just and equitable, reflecting an equitable balance between the public interest and the interest of those affected, having regard of all relevant circumstances, including the current use of the property. When I left, the property was guarded by heavily armed soldiers with dogs, as indicated in the record of court in Simonstown by Commander Dutton. So there was no rush for anyone to be coming in that particular house. The house stayed for a couple of weeks without occupation. The history of the acquisition and use of property, the market value of property, the extent direct state investment and subsidy in the acquisition and beneficial capital improvement of the property, and the purpose of expropriation. For the purpose of this section, the public interest includes the nation commitment to land reform and to reforms to bring about equitable access to all South Africans' natural resources, and property is not limited to land. Property also includes these items. The state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. A person or community whose tenure of land is legally insecure as a result of past discriminatory laws or practices is entitled to the extent provided by an Act of Parliament either to tenure which is legally secure or to comparable redress. That is why Parliament must act in terms of the Constitution in relation to this matter. It is not me. To the extent provided by an Act of Parliament, either to a tenure which is legally secure or to comparable redress. A person or community dispossessed of property after 19 June 1913 as a result of past racially discriminatory laws or practices is entitled to the extent provided by an Act of Parliament either to restitution of that property or to equitable redress. This is also what is being requested from Parliament. No provision in this section may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the result of past racial discrimination, provided that any departure from the provisions of this section in accordance with the provisions of Section 36(1), Parliament must enact legislation referred to in subsection 6. Section 36(1) is the limitation of rights, and those particular limitations must be done by general application of law. And general application of law brings us to Section 8 of the Constitution, which defines what application is. Limitation of rights in terms of Section 36(1). The rights in the Bill of Rights may be limited only in terms of law general application to the extent that the limitation is reasonable and justifiable in open and democratic society based on human dignity. Where is human dignity there? Equality and freedom, taking into account all relevant factors, the nature of the right, the importance of the purpose of the limitation, the nature and the extent of the limitation, the relation between the limitation and its purpose, and less restrictive means to achieve the purpose. Are these less restrictive means to achieve whatever purpose that any other person would have for a senior officer in the military to be on the streets? This is the action that needs to be looked at. This is the action that must be addressed in accordance with the provisions or these particular obligations imposed in terms of Section 25 of the Constitution. And to bring to your attention, except as provided for in subsection 1 or in any other provision of the Constitution, no law may limit any right entrenched in the Bill of Rights. Any right to education, right to children, environment in terms of Section 24. What right can one actually protect here in this environment? Going back to the third prayer. declaring that the plaintiff is not convicted to imprisonment for 5 years on account of offensive behavior in terms of Section 105 of the Defense Act as unlawfully and intentionally misrepresented on the DoD PESOL system since 8 August 2018. And SVM 3 is the subject to be looked at. SVM 3 is this particular PESOL information. In the PESOL information, it is application reason. It's OB. OB means offensive behavior section. It's 105 offensive behavior. The applicable section in this particular regard is this particular section 105. Section 105, like it reads, any member of the defense force or employee of the department whose verbal or physical conduct degenerates, humiliates, or shows hostility or aversion to any other person on the grounds of that person's race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, or birth is guilty of an offense and liable on conviction to imprisonment not exceeding 5 years. Where a member or employee of the department is convicted at any offense and the commission of the offense is accompanied by any offensive behavior contemplated in subsection 1, such person must be regarded as being such behavior must be regarded as being an aggravating factor in imposing sentence on the accused. So in reality, one must have been accused, one must have been convicted, and then such must have been in record of court, which is not there. So the reality is that I am not convicted, and having not been convicted of Section 105, this means this is a lie. And this is the lie that the National Assembly must correct. This is the lie that has been protected for the past 3 years. This is what tumamina means to other people: to destroy the lives of others, to make them miserable, to make them suffer in order to sustain criminal activity, corruption, apartheid, or misconduct antithetical to the supremacy of the Constitution and the rule of law. This information came to my light on the 3rd of June 2020, after a long time. And as a good soldier dedicated in service and defense of the country and its people in accordance with the law, in terms of the Constitution, one has requested a party to give this, and this has also been admitted as evidence before the record of court in Simonstown, and the court found that one has every lawful grounds to be in military premises. The only thing that prevails is the people that have committed this, which is Mr. Marcel Divet, having used the authority that he has used. Where did he get it from? It was from General Solishoke, who signed a letter on 8 August to send it to them for them human separation to do those particular issues. That brings us to these current aggravating circumstances today. So declare that I am not convicted to imprisonment for a period of 5 years is what the National Assembly must do, as prayed for. Declaring that no sentence involving discharge or dismissal was ever imposed upon the plaintiff under the code as obligated in terms of Section 59(1)(d) of the Defence Act as unlawfully and intentionally misrepresented since 17 August 2018. And then that is SVM4. SVM4. I made this thing simple for any other person that is looking at it and then wanting to understand, or who understands law. SVM4, this is the letter from Vice Admiral Hlongwane as the Chief of the Navy, who said number 4 Cable Hill Road is my address. And this was said on 17 August 2018. That is after 20 June 2018, because the correct address that the Chief of the Navy was supposed to employ in reality is this one. However, having regard that he is the Chief of the People's Navy and is obligated as his first duty to care for his employees or his men, he then on 17 August gave me this address. But for being in this address, for following this particular order, a person is imprisoned, as was the case. So it comes to Lieutenant Commander, it says administrative discharge. I do not know what is the meaning of this administrative discharge. The judiciary has been asked to call the signatory of this particular letter to come and account for the meaning of this particular phrase in law, but it is not known as to what it is. And the judiciary refuses to treat Vice Admiral Samuel Hlongwane as an equal person before the law. And in fact, any other organ of state, including the South African Human Rights Commission, refuses to call Vice Admiral Samuel Hlongwane to come and account in relation to this particular matter. And then now, the legislature has imposed an obligation that the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. The legislature is now called to uphold that particular reality. It is with regards to a letter dated 26 July, and then this particular letter was not made available to me at the time until it was made available and is on record of court at the Simonstown Magistrate Court. You are hereby notified that approval has been granted for your administrative discharge. You are required to hand back all personal loan items as reflected on enclosed distribution account report, except for the jacket cold weather. And I would want to stick to this context. The jacket cold weather is by statute and policy a returnable stores item, and you would refer this as the Chief of the Navy possibly maybe having to scorn a senior officer to say he must remain warm in this particular environment. Be it as it may, the Chief of the Navy has every reason to come and then explain before the National Assembly as to why did he digress from directives and policies regulating distribution accounts. These items must be returned to Naval Base Simonstown Logistic Department within 5 working days after receipt of this letter. Failure to comply with this instruction will result in a deduction from your final payment. 5 days I must return them. And I went to the Naval Base Simonstown to say, hey, I am here, there is this letter, and then I was shown, oh no, you are not allowed entry here. You cannot enter. They said we must not allow you to enter in Simonstown in Naval Dockyard. And then now what do I do with this letter? No, it is what we are told today. They know about the letter, but we are told today that you are not allowed to enter. You are further informed that the outstanding debt of your for studies at state expense of 2014 will be deducted from your final payment. I am currently unable to finish my master's as a registered student at CPUT, and for whose supervisor is Dr. Joa, and my current aggravating reality, and this particular reality, it puts me in a position where I cannot study in this environment. I cannot function in this environment. My right to education is grossly violated in that regard. And you are required to confirm receipt of this correspondence in writing within 5 working days. And then within 5 working days, I have billed the Minister of Defense 15 billion in terms of case number 12096 of 2018 before court, because I was not allowed to bring any other thing in my unit where I was supposed to, as directed by this letter. So when you look at this letter, it talks about discharge. When you look at discharge as contemplated in terms of the Defense Act, it is in terms of section 59, and section 59 will take you to this particular reality. Good people, I do this to educate you in terms of the due diligence that is taken in this regard. And then when Parliament says, no, Mangolele, you did not obey the law, then I would be put in a position where I do not know what else now to do, because we are sitting with the reality where this is the law of our country, this is the law that everybody must follow, but people are not following it. The termination, the services of a member of the regular force is terminated if he or she is sentenced to a term of imprisonment by a competent civilian court without the option of a fine, or if a sentence involving discharge or dismissal is imposed upon him under the code. This is where you find discharge. Any other way, there's no discharge there. It's an issue of upon expiry of 3 months, a date the member lodged, there is a resignation. This is a resignation. And then on termination of any fixed term contract between a member and the department on expiration or any extended period of such contract. Or if he or she has reached the prescribed age, this is a retirement age, and then if this is the discharge one, and then this is the medical issue in terms of terminating the services. You understand? So this is the reality that has been done. But whatever it is, one must have stood before a court, and then the court must have found the person guilty to say, Mangolele, you are guilty of this thing, and then a sentence of discharge is imposed upon you. Or what? Other people are saying it is something that they have cooked up on their own, and they are called to come and show cause in that particular regard, as explicitly set forth in the documentation before you. So, to go back to another prayer that is before the National Assembly, is declaring that in no event did the second defendant cancel the plaintiff's permanent commission as obligated in terms of Section 54(3)(a) of the Defence Act. My permanent commission is shown in SVMM 5. Excuse me. This is the permanent commission. The problem I have, it is this South Africa that is on my shoulders. And with this commission, I said, by the power vested in this rank, Lieutenant Commander Sylvester Volane Mangolele commands all South Africans employed in terms of the Constitution and the law, united in their respective constitutional obligations, to arrest the decline in critical capabilities through immediate directed interventions so as to rebalance and reorganize our country as a foundation for future growth. This was 2020-07, the 1st of July. And it was the Community Service Center of the South African Police Service and in Stilfontein. It is a lawful document. The order given here is a lawful order by myself. If you are employed in terms of the Constitution and the law, united in your respective constitutional obligations, constitutional obligation of the court and constitutional obligation of the South African Human Rights Commission, constitutional obligation of the Public Protector or any other Chapter 9 institution, constitutional obligations of all organs of state, they must arrest the decline in critical capabilities through immediate directed interventions. And when we go to Section 54(3)(a) of the Defence Act, it imposes an obligation that only the President may cancel a permanent commission. Only the President, which is the fifth incumbent. But such a commission may not be cancelled without the holder thereof, which is myself, being notified in writing of any complaint or charge made against him or her. And I have never received anything in writing from the incumbent President Cyril Ramaphosa in relation to a complaint or charge made against me, and of any action proposed to be taken in respect thereof, nor without him or her being called to show cause in relation thereto. And in retrospect, I call all those involved to show cause why I must not cancel their permanent commission. Fellow South Africans, I have a duty as a soldier, as the defense force, to ensure that the law is upheld, defended, and respected. Declaring that the plaintiff was not heard or granted an opportunity of being heard by the Honorable Davis J. on 14 September 2018 as obligated in terms of Section 21B of the Vexatious Proceedings Act of 1956, and rescind in terms of Section 21C therein the order issued under case number 15141 of 2018. And when we go to that order, as VMM6 is the order, I will take you to the order. The order says in terms of Section 21B. Stop there. Let's go to Section 21B of the Vexatious Proceedings Act. It's not here. I must go find it. Vexatious Proceedings Act, Vex Where is it? We are doing this in accordance with the Constitution and the law. And this is the law. Section 2 of the Vexatious Proceedings Act, it says, if on an application made by any person against whom legal proceedings have been instituted by any other person, or whom has reason to believe that the institution of legal proceedings against him is contemplated by any other person, the court isn't satisfied that the said person has persistently and without any reasonable ground instituted legal proceedings in any court or in any inferior court, whether against the same person or against different persons, the court may, after hearing that person or giving him an opportunity of being heard, order that no legal proceedings shall be instituted by him against any person in any court or any inferior court without the leave of the court or any judge thereof. So, when you come to this particular reality, you find that this thing is in terms of this, meaning that it must pass all these particular terms, which includes after hearing or giving him an opportunity of being heard. After you heard me, only that you can order that as it has been ordered here. And C of the Vexatious Proceedings Act, and for an indefinite period, no legal proceedings shall be instituted by the first respondent. So, before we even go further and then I waste your time with regards to this particular issue, you understand that we must first pass begin. Do we qualify in begin? No, we don't qualify in begin. And that means every other thing in there is unlawful. In fact, it is vexatious. It is without any, if it is without, where? It is without any reasonable ground. Because if you did not hear me or grant me an opportunity of being heard, then you don't have any reasonable ground to come to this part to order that no legal proceedings shall be instituted. It is as simple as that. That is how you make argument in court, and then that is what argument I have made in many courts. They don't want to listen to that because they have told themselves that no, Mangolele, whatever he wants, he must not get it, because the reality is that we must keep on keeping this particular lie about Mangolele. This is the fundamental lie that every other person is protecting. Mangolele is convicted to imprisonment for a period of 5 years as obligated in terms of Section 105. Even if I die tomorrow, my family will be faced with this, and they will tell you, no, our brother was never convicted to imprisonment for a period not exceeding 5 years. So, fellow South Africans, I'm here to clear my name, as you can see. So, Davis J has committed fraud in this regard because he has misrepresented the primary fact that I was there, while the reality is that I was not there. It is the same reality that you find even here, where now everybody says no, Mangolele is in jail, as it is the reality on the DOD PESOL system. Declaring that antithetical to the constitutional court order issued in terms of case number CC 12 of 2020, The plaintiff's rights to human dignity and life are entirely protected by the Table of Non-Derogable Rights in the Bill of Rights of the Constitution, and that the best interest of Nyiko Mangolele and Aluta Songelwa or any other child are of paramount importance in every matter concerning the child. I'm asking the legislature to declare contrast to what the Constitutional Court has declared in this particular matter. Because my rights as the plaintiff to human dignity and life are entirely protected by the Table of Non-Derogable Rights. Let me show you the Table of Non-Derogable Rights. It's just here. You see, for you to read the Table of Non-Derogable Rights, you must read this. This is the backbone of the law, our law. This section is the backbone of all sections. Of all of them, it is the backbone. It says, no act of parliament that authorizes a declaration of a state of emergency. A state of emergency can be this. You don't have to be in a state of emergency as an entire country. You can be in a state of emergency as an individual, just like your geyser would burst. And what is that? Is that not a state of emergency? Is this not a state of emergency? If I am asking you, are you not in a state of emergency here? Everything is emergency. Where do you cook is emergency. Where do you go to the toilet here? It's emergency. Where do you sleep here? It's emergency. Where do you wash here? It's emergency. Where is the potter for you to relieve yourself when nature calls? It's emergency. So this is a state of emergency. And no legislation enacted or other action taken in consequence of a declaration. No legislation enacted. You cannot enact a legislation, or you cannot take another action in consequence of this particular declaration to authorize or permit indemnifying the state or any person in respect of any unlawful act against me. People send me to jail, no one gets punished. We sent him to jail for 6 months and no problem, so what? And while we sent him to jail, what happened? The state was indemnified. Any person who did any wrong to me, this wrong that you see here, this wrong that you see here also, it's fine. They must continue receiving a salary. This wrong that you see here about administrative discharge, Vice Admiral Samuel Hlongwane is continuing to receive a salary, while Mangolele, who follows the law, who even tries to follow the letter of Vice Admiral Samuel Hlongwane, is arbitrarily or without just cause deprived his salary. Any derogation from this section, no act of parliament that authorizes a declaration of a state of emergency, and no legislation enacted or any other action taken in consequences of a declaration may permit or authorize any derogation from this section. This is one section in the Constitution that tells you that you cannot derogate from me. It tells you straight. It is this only one section that you cannot derogate from this one. Yeah, I want you to do anything and anything and anything. You cannot derogate from this one. Or any derogation from any section mentioned in column 1 of the table of non-derogable rights. Where is column 1 of the table of non-derogable rights? Column 1 of the table of okay, section 9, section 10, and then 13, 28, and 35. You can't do anything with these sections. These are the cream of the Constitution. Simple terms. To the extent indicated opposite that section in column 3 of the table, extent to which it is protected. So now, equality, it is protected, everyone is equal, but in a state of emergency, with respect to unfair discrimination solely on the grounds of race, color, ethnicity, or social origin, sex, religion, or language, you cannot be discriminated against that. What is this thing here? Is this not discrimination? Don't be scared to look at this picture. Is that not discrimination? It is discrimination. Who wants to live here? Ramaphosa, do you want to live here? Can you live there for 3 years as I have in this? But don't confuse the reality that I am able to live at a friend's place or at any other person's place. Now my place, in accordance to the Constitution and the law as determined by the powers that be, is this one. Or I went left or I went right in this regard, that doesn't matter. My constitutional address is this one. When the people that are looking for me constitutionally, they will expect to come and find me in this address where they put these things. It's like when I take at something and then put it there in that corner, I expect to find it where I put it. Human dignity is entirely protected. Life is entirely protected. Good people, you cannot find any reason not to protect these things. No court can find any reason not to protect these things. Where do you protect human dignity and life here? In simple terms, where do you protect human dignity and life in this regard? It is not for the happy. So, every single time people have been doing the opposite of the law, and that is the administration of the incumbent Cyril Ramaphosa, because this matter, the Constitution doesn't only apply to the courts, it applies to all organs of state. It applies to all organs of state. Even in the meeting that you are having right now and that you had today, you had to apply the Constitution. You could not say to another person anything that is outside the context of the Constitution or that violates the Constitution. Now, why does it not apply? Do you see my reality now? That is the reality that needs to be dealt with. So now, when you go to this order here, while we are there, I will show you, before we get to the technicalities of this particular order, the application is there. And then the application says, take notice that Lieutenant Commander Sylvester Volane Mangolele, here after called the plaintiff, intends to make application to this court for an order declaring this action an urgent action and dispensing insofar as is necessary with the forms and services provided for in the Constitutional Court rules in terms of Rule 12, when each party will lead oral evidence, which in turn may be tested under cross-examination by any party in order for the Honorable Court to come to a decision in terms of Section 10, 11, and 28. The court must entirely, and the court must, with respect to subsection 1, D and E, the rights in subparagraphs 1 and 2 of subsection 1G and subsection 1I in respect of children of 15 years and younger. Let us look at 1D and E and 1G. 28 1D and E. What is 28 1D and E saying? You need to understand what is meant. Section 28 1D. Every child has the right to be protected from maltreatment, neglect, abuse, or degradation. My children are degraded without their father, who must come and fetch them with his own car and take them anywhere where they want to go. Or my children are degraded as they are not going to school, they are abused, they are neglected, they are maltreated by my absence. Their parents, they will tell you they are fine, but you know as a child what happened to you when your father or your mother was not there. To be protected from exploitative labor practices. That is in relation to a 15-year-old. 1G, 1 and 2, kept separately from detained person over the age of 18, and then treated in a manner and kept in conditions that take account of the child's age. Not to be used directly in armed conflict, and to be protected in terms of armed conflict. These you cannot degrade or derogate from these rights in terms of the table of non-derogable rights. Sorry, we don't understand. We understand. So people, with regards to Mangolele, they have just only taken the law into their own hands. And so a child when he's more than 15 years, when he's 16 years or above, Hadibowa, we can take them to war and train them and then get them to that particular point. So arrested and detained persons, they also have got their rights that are non-derogable. And now that you understand the non-derogable rights, and then declaring that the plaintiff has inherent dignity and the right to have his dignity respected and protected, the Constitutional Court had to declare that, né? And it must do that entirely. Look at that. I want you to see what had happened here. It is good to sing when all is bad. Even when the Titanic was sinking, music kept playing. Human dignity, everyone has the right as inherent dignity and the right to have their dignity respected and protected, was what I asked the Constitutional Court outside the context, declaring that the plaintiff has inherent dignity and the right to have his dignity respected and protected. Was it outside the contents of the Constitution? No. So the legislature must look at this particular matter in accordance with its terms, declaring that the plaintiff has a right to life. Everyone has a right to life. Constitutional Court refused to declare that, declaring that the plaintiff is free from slavery, servitude, and forced labor. No one may be subjected to slavery, servitude, or forced labor. Aye. Declaring that a child's best interests are of paramount importance in every matter concerning the child. This also includes the plaintiff's children. And we all know that do know the Constitution, that it is true that a child's best interests are of paramount importance in every matter concerning the child. In any event, everything in this matter was in terms of section 10, 11, and 28. And the Constitutional Court considered this matter and said, the Constitutional Court has considered this application for direct access. Let me take you to the Constitutional Court rules. Direct access is in terms of Rule 18. In fact, I don't have to show you that. I know the Constitutional Court rules. You may refer to them. It's in terms of Rule 18 of the Constitutional Court rules. Whereas this particular matter is in terms of Rule 12 of the Constitutional Court rules. It has considered that the application should be dismissed as it does not engage this court's jurisdiction and in any event bears no reasonable prospects of success. So in any event, I have no reasonable prospects of success for my child's best interest to be declared as paramount importance in every matter concerning them. In any event, I have no reasonable prospects of success to have my human dignity entirely protected as obligated in terms of the table of non-derogable rights. In any event, I have no reasonable prospects of success to have my right to life entirely protected as obligated in terms of the Constitution. In any event, I bear no reasonable prospects of success. In any event, it means even this particular event. You must not believe me when I tell you that my human dignity is entirely protected. Are you seeing now the opposite? Here you are saying you will never get your human dignity, Mangolele. And that is said by these justices, Mogoeng, Jafta, Kampembe, and Mandlanga, Majid, Matapo, acting justice, and then Justice Mhlandla, and then Justice Theron, Justice Chipi, and then Justice Victor, acting justice. They say, Mangolele, Aronas Constitutional Court, you are never, Papa, going to get these things. So, fellow South Africans, I want you to understand what the context of this particular matter is and how heavy and deep this particular matter is in relation to its terms and the supremacy of the Constitution and the rule of law. And here we go again. The court has decided not to award cost. So all the 27-page document, 27 copies that I have made with difficulty, the cost thereof doesn't matter. Or a motor ticket transport from Mogogelo to Johannesburg and that, it doesn't matter. What we are protecting, Rona, here is that when you are in jail for a period not exceeding 5 years. Now, what I want you to take into account is that you will see here in the order, in the application that is issued, and this is one other thing, you don't see what is happening in the background. You only see a court order and then you believe a court order. Yeah. In any event, he bears no prospects of success. You don't know what was requested for. And that is now abuse of power. at play, because you are expected to trust what the Constitutional Court is saying. And in service and defense of my country and its people, I cannot have justices in the Constitutional Court that are incompetent, as is the case. You cannot have any room for error in the Constitutional Court, as the Registrar, Mr. Makaka, has told me that the Constitutional Court is a place of compliance. However, the Constitutional Court in itself, it has failed to notice that Lieutenant Commander Mangolele is the plaintiff. And it represents Lieutenant Commander Mangolele as just only Sylvester Volane Mangolele as the applicant. I did not apply. I did not say I'm an applicant. I said I am complaining. I am the plaintiff. And in my complaint, I want you to do these. The Constitutional Court, misrepresents the state of the Republic of South Africa as the first defendant and say, in this matter that we have judged, the first respondent is the President of the Republic of South Africa. There's no state. Effectively, you have 14 respondents instead of 15 defendants. And what happens even further is that the Chief Justice here is the fifth defendant. Chief Justice is called, and in an event where the Chief Justice is called in a matter, the acting Chief Justice would either be the Deputy Chief Justice or the judge, the President of the Supreme Court of Appeal, or any other senior judge designated to act in terms of on behalf of the Chief Justice in that particular regard. In the order, because the state is not there now, the Chief Justice is misrepresented as the fourth respondent, not the fifth defendant. The Chief Justice here judges himself. Justice Jafta knows that the Chief Justice is called. Justice Kapempe knows that the Chief Justice is called as a respondent or a defendant. Justice Majid Madanga, Acting Justice Matapo, and all other justices in the quorum, they knew and have applied their mind to say, it's okay, Chief Justice, you can come and then judge yourself. And all these things, they happen when I'm not there. I have requested and specifically requested to lead oral evidence. The Chief Justice and these other justices do not know what is the meaning of oral evidence when they make an order in my absence. A complete abuse of power. Urgent application on 21 January 2020 in terms of Rule 12 of the Constitutional Court rule is unlawfully and intentionally misrepresented as direct access application in terms of Rule 18. The quorum unlawfully and intentionally allows the Chief Justice to judge himself. The Constitutional Court is unlawfully and intentionally misrepresented to have no jurisdiction in constitutional matters. What is entirely protected by law is unlawfully and intentionally misrepresented to mean that the plaintiff has no reasonable prospects of success in any event, to have his right to human dignity and life entirely protected as an obligation imposed by the supremacy of the Constitution and the rule of law. This applies mutatis mutandis to Nyiko Mangolele and Aluta Songelwa, Papa O Teng. Fellow South Africans, this is a prayer that is there before the National Assembly. And the National Assembly is further asked in prayer to declare the immediate retrospective reinstatement of the plaintiff's salary, benefits and allowances to be paid into the following banking details. Approve the plaintiff's travel arrangement at the first defendant's expense from Cape Town to Mogogelo for the plaintiff to see her 83-year-old grandmother Leta Kukunana Majila before it is too late. And in this regard, I would particularly like to take an opportunity of saying to all of you, Leta Kukunana Majila has suffered and is suffering. I ask all of you to understand that she is suffering, and then that because she is suffering and because she is the last born of the Mabuse family, the last born of Frederick and Maria Mabuse, the entire tree of Mabuse is looking at her in despair and suffering. This does not only affect me alone, it affects my entire family. My entire family is hurt by this. My entire family does not even want to talk to me because I am the subject of the hurt that is perpetually continuing with impunity as a result of criminal activity, corruption and misconduct. This corruption and misconduct, or criminal activity and apartheid, has caused me to be in a position where I'm unable with dignity to care for my family. I'm unable with dignity to care for my children. I am made as if I am an irresponsible parent, while I am that particular parent who married the mother of my firstborn and had every intention to be with the mother of the secondborn. Unfortunately, due to irreconcilable differences between ourselves and the mothers, we have separated. But separation between parents does not mean separation from parent to child. In terms of Rule 43 applications in the High Court, you would understand it to be true, the statutory provisions of that particular rule, that in no matter are the best interest of the child can be compromised. And my children need to see Leta Kukunana Majila before it is too late. I am hurt by this particular reality, and I am asking and requesting the National Assembly to uphold the rule of law and its supremacy. Fellow South Africans, I wish not to tell you about how deep my finances have been grossly violated and how deep one has suffered to a point where all this suffering must be dealt in terms with Section 84(2)(j) of the Constitution, where the second defendant must pardon or reprieve the plaintiff and remitting any fines, penalties or forfeitures. And the second defendant must, in terms of Section 84(k), 2(k) of the Constitution, confer honors to the plaintiff. And now it comes to where we compel the first defendant to fulfill the obligations imposed by the Constitution and respect, protect, promote and fulfill the plaintiff's rights enshrined in the Bill of Rights as obligated in terms of Section 7(2) of the Constitution. The Bill of Rights is, I want all these rights in Chapter 2, all of them. That is just administrative action, access to information, cultural, religious and linguistic communities, language and culture. My culture dictates that when I come from prison, I must go tlapisiwa ka meriana. You get what I'm saying? Go gae. I am unable to go gae simply because people refuse to remove this particular lie on my name and uphold the supremacy of the Constitution and the rule of law, to punish those who have betrayed the Constitution, to lie to all people and say I am convicted to imprisonment for 5 years without an option of a fine as obligated in terms of Section 105 of the Defense Act, good people. So everything else follows suit, and you need to understand these particular realities that are there. These are the rights that I want: the right to education, the right to children, the right to health care, food. I don't have this right to health care, food, water and social security. It's not there right now. As a person, equal before the law. I don't have a right to housing. Where is that particular right to housing when you are sitting in this particular reality? Where is that right to housing? It's not there. Fellow South Africans, I ask for all my rights. And then in asking for all my rights, I am in this particular position where one is obligated to do all the things that must be done and then follow the law accordingly. All these rights are the rights that I wanted. The rights to an environment. Is this an appropriate environment that one must be at the time? It is not. That is not harmful to their health, well-being. Is this environment not harmful to my health and well-being? It is. Good people. So the rights to labor relations, where everyone has a right to fair labor practices, and then fair freedom of trade, occupation, and this people, they keep on saying Mangolele is in the persona non grata. How can you be persona non grata while no citizen may be deprived of citizenship? And every citizen in the Republic is equally subjected to the law, Constitution and the law. That is the reality of the matter, good people. And in this particular reality, you find that one has done everything in accordance with the Constitution and the law. And everything in here, good people, is in accordance with the Constitution and the law. In an event it is not, please forgive me as a person who have tried by all means to follow the Constitution and the law. In terms of Section 89 of the Constitution, remove the second defendant on the grounds of serious violation of the Constitution or the law, serious misconduct, inability to perform the functions of office. Section 89 of the Constitution tells you straight that you will see it. When you want to remove the president, this is what must happen. It is not the court that must remove the president. It is the National Assembly, by resolution adopted with supporting vote of at least 2/3 of its members, may remove the president from office only on the grounds of a serious violation of the Constitution or the law, serious misconduct, serious inability to perform the functions of office. President, because you were respondent in this particular matter, you are there. You were called to come here and uphold. That's all that you were called to do as the President of the Republic. Uphold, defend and respect the Constitution as the supreme law of the Republic and promote the unity. Unity is for me to be with my children, not to be apart or be kept away from my children. No. Unity is when I'm with my children. Is that unity being promoted? Nope. And that which will advance the Republic. You see. So that is what you were called here to come and do. And then now, people willingly here, having regard of the manner of arriving at decision by a constitutional court. No judge may sit at the hearing of an appeal against a judgment or order given in a case which was heard before him or her. They can't. So, Chief Justice here could not have judged himself, as he is called. And when as president, you agree now, you keep on paying Chief Justice salary. My friend, Mokhweng, we love you. I'm not going to uphold the law, it's Mangolele. Mara, as president, I have taken an oath in terms of the schedule and then have said to this particular people that as President of the Republic of South Africa, in the presence of everyone assembled here and in full realization of the high calling, I assume as President of the Republic of South Africa that I, Cyril Ramaphosa Matamela Maphosa, swear or solemnly affirm that I will be faithful to the Republic and will obey, observe, uphold and maintain the Constitution and all other law of the Republic. And I solemnly and sincerely promise that I will always promote all that will advance the Republic and oppose all that may harm it. Is this not harming the Republic when a judge judges himself? What is it if it is not? Are you keeping to your promise? Protect and promote the rights of all South Africans. Am I not a South African? President Ramaphosa, did you protect and promote my rights? When these people have sent you, President, here, we are sending it to you, and then you will get it, and then Mangolele, in any event, there's no prospects of success. President, are you doing it? discharge your duties with all your strengths and talents to the best of your knowledge and ability, and true to the dictates of your conscience. Do justice to all. Is it justice when I am being thrown out of court, when I'm being sent to jail for a crime committed by other? Devote yourself to a well-being of the Republic and all its people. Am I well, President? Is that not a gross violation of the Constitution, or inability to perform the functions of office, or serious misconduct to allow people to judge themselves? Are you not party to this particular proceedings as called? Or they don't matter to you? It is the law. I wrote the law. People must follow it, but I will not follow it. And when they don't follow it, because they are my friends, I don't care. We run the state like that in a democratic Republic of South Africa. It cannot follow to be in this particular manner. That is why the legislature is employed in terms of Section 180C of the Constitution to also remove the third defendant, which is the Speaker of Parliament, from office by resolution as obligated in terms of Section 52(4) of the Constitution. Call for the removal of the fourth defendants by resolution or as obligated in terms of Section 1771B of the Constitution. I will take you there. Section 1771B. Judges, they think, no, we can't be removed, and then because we control the process and what, we can't be removed. Check here. Any judge may be removed only if two conditions must meet one of the conditions. And the condition that is imposed is this one. The National Assembly called for that judge to be removed by a resolution adopted with a supporting vote of at least 2/3 of its members. This is what I want. Don't tell me, Judicial Service Commission, you did not complain. National Assembly, it's what I want you to do. Are you allowing a judge to judge themselves? Are you allowing other judges to allow the other judges to judge themselves? Which one are you doing? Fulfill the obligation imposed in terms of Section 1771B of the Constitution and remove this quorum. That's all I'm asking you to do. In service and defense of my country and its people, this quorum cannot continue to earn a constitutional salary after what you have seen in this particular video. I have followed the law to the letter. I have applied the law to the letter, and the defendants must be ordered to pay cost. The cost will follow after this. Let's not confuse this with manifest. Let's do what needs to happen. I have done my best to explain to all of you. This basically will take 2 hours of any person's time that is dealing with this matter to actually see all the facts surrounding this matter, the actual critical facts that are factual and that cannot be disputed in any other way. So, fellow South Africans, I have done this particular job, and then I will take this particular issue and email it to Mr. Xaso, or all the people that I have emailed yesterday in this particular regard. So, without any further ado, fellow South Africans, I ask all of you to teach your children to live and enjoy freedom in the universe, our home, and tell them that Papa O Teng